I'll call the House Judiciary, Finance, and Civil Law Committee back to order. Y'all are a lively bunch for this late in the day. The first bill on the agenda this evening, we have a quorum, by the way. I guess we don't have to announce that second time, do we? The first bill on the agenda this evening is House File 2825. Representative Hudson, would you like to move House File 2825 be passed and placed on the general register?
That is my motion, Madam Chair.
All righty. With that, the bill is before us. I don't believe there are any amendments. No. So go ahead and speak to your bill, please.
Thank you, Madam Chair and Chair Liebling. I'll start out by saying that today marks my high score for bill presentations in one day. And that is due to the grace of both chairs. I particularly want to call out Chair Liebling for, first of all, having the foresight to recognize that this does indeed impact data practices and therefore requires a hearing in Judiciary, and then having the grace to allow us to slip it in at the last minute for consideration today. So what House File 2825 does is it would allow expunged records to be accessed as part of a background check on a person seeking to be a licensed or licensed as a private detective or to provide private security services. And this is something that would align our vetting of potential employees of security agencies and private detective agencies to have the same sort of scrutiny that is currently provided to our other public safety officers when they go through their background checks. So what they're looking for, as my testifier will expound upon, is they're looking for past convictions that would disqualify someone from being able to be licensed as one of these private security officers or a private detective. And that currently is something that they are to some degree obstructed from doing by virtue of our continued practice of increasing the number of expungements. And with that, I will turn it over to my testifier.
Mr. Hodgson, go ahead and state your name for the record and go ahead with your testimony.
Thank you, Madam Chair. My name is Richard Hodgson, Hodston. I am here today wearing my hat as a public member of the board that licenses private detectives and private security officers in Minnesota. I am the board chair as well, and the longest-serving member of the board. As Representative Hudson indicated, we are not looking to expand or reduce or restrict or any way who is eligible to be licensed. The legislature has already established that certain criminal convictions make someone ineligible to be licensed. For example, assault, gun crimes, felony theft. You probably don't want those people guarding your property. And so what the legislature did in the expungement statute, Chapter 609A.03, said that certain convictions should be made available, for example, for law enforcement employment. We don't want felons working as police officers. And what was missed years ago when that statute was enacted is our board was left out of that exclusion. This would allow our board, when someone applies for a license to work in this industry, to protect your persons, your property, your children, public venues, for us to make sure that they are not have a history where it's been proven beyond a reasonable doubt that they committed these crimes. And so we're simply trying to be able to find those individuals to make sure we do what the legislature has already told us to do, is to make sure we have the right people protecting our property. And I think I have submitted, and yesterday I did submit more extensive material. I hope the committee is, I know we're playing catch up here and I appreciate that. I hope you've been able to get it. I certainly can respond to any procedural or substantive questions.
Thank you for your testimony. Is there anyone in the audience wishing to testify on this bill? Seeing no one else, we'll move to member questions. Members, do you have questions on this bill? Chair Liebling.
Thank you, Madam Chair, and thank you for being here this evening to talk about this important issue. So what are the, I think, Mr. Hudson, you mentioned that you want to make sure that people who have certain convictions can be screened out of employment. And could you be a little more specific? I mean, what is it that you're looking for that you would want to be screening out here?
Mr. Hodgson.
Thank you, Representative. That's already been established by statute. We're not asking to change that at all. And the statute that already tells us who must be screened out is found in Minnesota Statute 326.3381, subdivision 3, parentheses A. And it lists the criminal convictions, for example, felonies, gun crimes, receiving stolen property. So they're listed in the statute, Representative, if that helps give you some guidance.
Okay, well, and I'm sorry, I know I have this letter in front of me, but honestly, I haven't had a chance to read it, or as you said, you distributed. We brought, the bill came late, and we made an effort to get it in and so on, kind of getting in right under the wire here, so we haven't had a chance to really look at it the way we might like to, but, so do you, has this is, I think, been, I don't know when we passed the exception for the police officers for criminal justice agency. I think it was somewhat recent, but has there been a problem here? I'm just wondering, what is the real problem that you're solving?
Yes.
Mr. Hudson.
Thank you. The legislation that expanded the scope of expungement was passed in the 2014 legislative session, was effective January 1st, 2015. And even at that time, there was an exception for criminal justice employment. Where things are changing is the scope of expungement. The policy decision has been made to expand the scope of expungement, first effective January 1st, 2015, and now effective January 1st, 2025, with the so-called automatic expungement or Clean Slate Act expungement. That's happened. Okay, we accept that. But what we have seen already is individuals who have applied for licenses. And we've already had at least 2 cases where they've applied for licenses. They also applied for expungement at the same time. The process of the court, but they had to go through the court process for that. So by the time they got around to the court process, we'd already been able to run the record checks. So we already knew that by state statute, we should not have issued them a license. Our concern is, as people now figure out the proper sequence, first they go in, the record becomes sealed. A sealing of the record, according to the Minnesota Supreme Court, doesn't undo the conviction. So we're in a bind. We're not supposed to legally issue a license, and yet we might accidentally do that. This is to try and prevent that from happening.
Chair Liebling.
Thank you, Madam Chair. I guess what I'm really struggling with this bill is that when we do expunge, and I hope some of my colleagues who know more about this than I do will maybe speak to it here on both sides, but when we expunge records, my understanding is the very point of that is because there's been a decision that either the nature of it or the time that's gone by are such that a person should not be barred from certain things that they would be barred from if they didn't have the expungement. And so I'm kind of wrestling with, I know we made an exception for criminal justice agencies, and I think what you're sort of suggesting here by being here is that this is kind of akin to being in a criminal justice agency, but I'm not really sure that that's true. I mean, you're asking for, the bill is for, this is for security. Well, maybe I could just ask you, who would be covered under this bill?
Mr. Hodgson.
Madam Chair, Representative, the statute that we are contemplating would cover licensing, individuals who are licensed to perform that function. And in order in Minnesota to legally be a protective agent, work for a protective agent company, or a private detective, you must have a license, meaning you're vetted, you're trained, and properly credentialed. So this would apply to those entities. But the state statute that I cited to you also says that if you work for those individuals, that you also must pass the background check. We don't license individual security officers and private detectives in Minnesota. We put the burden on the company to do the vetting. And in many ways, that's the same way we handle it for licensed peace officers. the post board, for example, when someone applies for a license to be a peace officer, and I want to give you too long a history lesson. I was the post board's first lawyer for 8 years, going way back to 1978, 1979. You wouldn't know that by my youthful appearance, but I was. But we have the police department and the sheriff's office do the criminal history record checks, the backgrounds, and then they convey that information to the post board and say, this person hasn't passed the background investigation. They've got an assault conviction, a theft conviction, whatever. And so that's the similar model we're using right now. We have the burden on the license holder to make sure that the people meet the requirements of statute. And that saves taxpayers money, because that means that they do that, they pay a fee. This is a revenue bill neutral bill. I want to make sure that everybody knows that as well. In this day and age, it's public safety on the cheap. But we do think that it is valuable that way. And to your point, Representative, that expungement doesn't actually, under Minnesota statute, and again, I'm not going to turn this to an expungement class because I teach that for thousands of cops. But what it does is seal the record to help employment except for professions we don't think it should, for housing especially, these types of issues. But some of the professions, like law enforcement, employment, like teaching, like running daycare centers, this body has decided, our legislature has decided, our public policy makers decided, if you're going to, for example, run a daycare center, you shouldn't be a child abuser who's been convicted. And again, I want to emphasize, our proposal is like law enforcement. It is actually more restrictive. We're only talking about convictions. If someone has been arrested and gotten diversion, or gotten a stay of adjudication that didn't result in a conviction, we're not dealing with those people. These are people where it has been, after a trial or a guilty plea, it's been determined by a judge and a jury beyond a reasonable doubt that they committed an offense, which are disqualifying offenses. If a check were to be run and they come back with even with a conviction that isn't a disqualifying offense, that will not fall within our board's purview. That will not change anything if this bill is enacted.
Chair Liebling?
I think that's all I have, Madam Chair.
Okay, thank you. Any other members have questions? Sounds to me like you're just sort of being put on par with other law enforcement officers, but with some special exceptions that you're kind of limiting yourself to. Is that a good synopsis?
Madam Chair, that's a very good summary. There are as many security officers in the state of Minnesota now as there are licensed peace officers. And as we have a shortage, as many of you are aware, we have a shortage of licensed peace officers. More and more companies are saying, we need to keep our consumers safe, our customers safe. So let's make sure that we have some kind of security. So private security, private detectives are filling that gap more and more.
Right, got it. Representative Finke.
Thank you, Madam Chair. And Representative for your bill, I just wanted to follow up on one of the questions that Chair Liebling had. You said that there's a statutory list of disqualifying, and is it, you'll have to forgive me, I know very little about being a private detective. But is it like, if you have one of these, you are automatically disqualified there, or is it like, okay, well, maybe there's a circumstance, or is there, because that to me is kind of like when I think about the expungements, and the work that I used to do, there was some expungement work. And, I just would like to get a better sense of it's like kind of like you have been convicted in the past of any of these things, you're disqualified. Is that accurate?
Mr. Hudson.
Representative, that is essentially accurate. There are always if, for example, if you really wanted to be a private detective or private security or run a company, you would have remedies. You could, for example, go to the Pardon and Commutation Board under Chapter 638. You recall in the last couple legislative sessions, their authority has been much more expanded. So if I really wanted to be the next Philip Marlowe, I would go to the board, and I had a disqualifying conviction, for example, a gun charge. And now my life is different. I don't carry guns illegally. I don't threaten people anymore like I did in my checkered past. I would go to the Pardons Board, make my case. If I got it, that would be an avenue by which then I could get back into the industry. And we do have individuals. We have one long-term licensed private detective, for example, who did exactly that. He had a federal conviction that was a disqualifier. President, shows you how long ago it's been, President Jimmy Carter pardoned him. And he has been a 40-year-plus private detective in security company. So there are avenues available. We just want to make sure that they get the avenue the legal way. And right now, we're worried that it wouldn't happen that way.
Representative Fink, you follow up?
Yeah, President Carter was very kind. Thank you.
You're welcome. Any other questions? All right. Representative Frazier.
Thank you, Madam Chair. Representative Hudson, thank you for the bill. Mr. Hodson, what if I was to apply for this license and I was approved? What special privileges do I have now that I didn't have when I was just a civilian?
Mr. Hodgson.
If you are a licensed, well, it would depend if you're applying for a licensed private detective, a private detective license or a private security license, because those are different licenses. If you wanted to be a licensed private detective and apply, you had the requisite training, et cetera, that would give you access, for example, to databases that no one else has access to. You could now run record checks through the Department of Public Safety. You would give you access to that kind of private data that non-licensed individuals don't have. It means you could earn money doing investigations without committing any crime. You have to have, it's a gross misdemeanor to do investigations without having a proper license. If you were going to be a private security company, likewise, again, you would be able to work in events, you would be able to drive armored trucks with firearms and haul money to banks and do those kinds of typical security functions that you could not lawfully do without a license.
Representative Frazier.
So thank you for that. That was helpful. So if and I understand the point, legal point you're making about the law being expunged is different than a pardon, but it's still the same activity, expunged or pardon. What changes? I mean, it's really just a legal distinction that the pardon says that the crime has been, the incident has been forgiven, and the expungement just says the incident has been sealed. Is that correct?
Mr. Hodgson.
Thank you. That largely is dependent on the legislature. The legislature has decided that for some purposes, a pardon or an expungement has the effect of setting aside a disqualification. For other purposes, it does not. For example, with the post board, if a person gets an expungement or even a pardon, the post board, by rule, which has the force and effect of law, like a statute, says that still does not restore their ability to become a police officer. We have a whole statute, Chapter 364 of the statutes. It's called the Ex-Offender Rehabilitation Act, which was enacted way back in 1975. And it generally says for professional licenses, for many public professional licenses, the fact that a person has got a criminal record or been arrested can, unless it's directly job-related, cannot be used against them. But going all the way back to 1975, the legislature said there are certain professions that are so safety sensitive that those protections don't apply. And the Board of Private Detectives and Protective Agent Services has, from day one, the legislature going all the way back to 1975 said, because of the public safety aspect of that, like for law enforcement, those we are going to put into this more reserved, higher standard of conduct category. So as I said, this is not at all a new concept. If we go back to 1975, that's even before I started practicing law, so that's a really long time.
Any other member questions?
Can I follow up?
Oh, I'm sorry. I thought you were done.
No, thank you. Thank you, Mr. Hodgson. So I guess the question just for my clarification, in this application process, if an individual was applying for private detective or protective agent licensing, is there a difference if I've been pardoned versus an expungement? Is there a difference in terms of how you look at that application?
Yes, as I indicated, we have an individual who has been a long-standing licensee who got a pardon.
Yeah.
So there are mechanisms. A pardon is absolutely different than an expungement. The Minnesota Supreme Court has ruled on 2 occasions that a sealing of a conviction does not have the same effect that a pardon does.
Yeah.
That case is State versus MDT and State versus, I can't believe I'm just about to do this. I'm sorry, I'm acting like I'm talking to a bunch of judges. I'm sorry. But there are, trust me, there are Supreme Court cases that do make that distinction. And I can certainly share that with you. Actually, I think they're in our written material.
Representative Frazier?
Thank you. No, and I don't mind. I'm an attorney, so I don't mind you
I
speaking
know you
that
are.
way. And I guess that's my point, is that in these particular situations, the board would look at this and say, if it's a pardon, regardless of if the situations or the convictions are similar, if it's a pardon, we will move ahead and grant the license, potentially. But if it's an expungement and we look at that record and we have access to those expungements, if it's the same crime and you have not been pardoned, we would reject that license.
Mr. Hodgson?
That's correct. The pardon does have a far stronger set-aside effect than simply sealing a record.
Another question? Representative Frazier?
Thank you. Just final comment. And I think, I mean, that's what I'm struggling with, is that there doesn't seem to be the type of the public policy decision to allow for expungements was to allow for people to move forward. Same with pardons. And I think there is some conflict there in terms of how we treat individuals with having a pardon versus having expungement, and particularly where there may be the same instance that led to those particular incidents that they may have been convicted of. And I'll leave it there, but that's what I'm struggling with there.
Thanks, Representative Frazier. Representative Liebling, did you have another comment?
Yeah, thank you, Madam Chair. So I think and maybe where Representative Frazier is kind of going, I'm a little bit struggling with too, because the real question here for us is, if we allow the expungement to be opened for purposes of this, then the real question is, should people who have an expungement of an offense that would otherwise disqualify them, should they not be able to get these jobs? Are they somehow not safe or not capable or something of doing these jobs such that we should open up the expungement that they've been given? I wish I understood more about expungements, because frankly, I don't really have that background, and we don't really have time to do that now. But I really think for us as policymakers, that's really the issue, because as I think you've been saying, Mr. Hudson, it's really a matter of law how these things get treated, and that's what we're here to do. That's what we're here to decide. And on what basis do we decide? I think it's for us to decide whether in this context, an expungement should mean that record stays sealed, which means that these people get the job or not based on other things. And I just don't feel like I understand enough here today to say that we should allow that expungement to be opened. I appreciate the bill being brought. I appreciate thinking about the issue, but personally, I'm just really not ready to, just because this is so quick, I don't have the background for it. I just don't feel I can support this today. So thank you.
Representative Hudson, a word, and then we'll go to Representative Engen.
Sure. Thank you, Madam Chairs. So I very much appreciate the conversation that this bill has generated, and I will note that it's gotten far more scrutiny here in Judiciary than it did in public safety, which is a testament to the detail-oriented nature of our members. What I'll say is, and I'm going to try to offer this in as unbiased a manner as possible. When we consider the legislative intent of existing law, obviously the intention of the statute that Mr. Hudson is referencing was that folks who have received a conviction for certain crimes should not be entrusted with these licenses or working for somebody who holds these licenses. And I think the rationale for that is very similar to the rationale for allowing law enforcement agencies to do a criminal background check to find out if somebody, and to open expungement records to find out if somebody's had certain convictions. And the reason for that is we balance in public policy the concern of safety against the concern of access. We do it all the time. People have rights to access certain areas and to do certain things, but we curtail that when there is an overriding safety concern. And in particular, when we're talking about, because again, I understand the intent of expungement, I understand where Representative Frazier and Chair Liebling are coming from, that the intention of expungement is to offer somebody a second chance to move on with their life. The question becomes, is that just an open door to do anything? And we've already decided, as a past legislatures have decided, that it is not an open door to become a peace officer. And I would argue or speculate that the rationale behind that is because when you become a peace officer, you're endowed with a tremendous amount of trust and authority that you wouldn't otherwise have. And that is a responsibility that needs to be wielded by someone who has a high degree of character and trustworthiness. Now, as a private security officer doesn't have the same authority as a law enforcement officer, but they do have a tremendous amount of access. And I say this as someone who worked for much of my young adulthood in this industry, the private security industry, in various venues, various roles, supervisor, manager, armed and unarmed, all different types of environments. You have access to everything. Like the folks who protect us here have key cards that can get them in the places that we can't, right? You have access to every place. You're encountering the public, you're encountering personnel and staff, and you're endowed with this protective trust. That properly should merit a higher level of scrutiny regarding your character and your ability to be entrusted with that responsibility. Thank you, Madam Chair.
And I think of situations like there are private security guards that hospitals
Yes.
hire. Maybe there's a private security guard outside of a women's shelter. And we want to make sure that those people don't have a, as you said, checkered past, you know, and it's up to the private company to decide. Am I right, Mr. Hudson? So if the hospital is looking to hire private security guards, I guess they're probably hired through a private company to supply that, but the hospital would want to make sure that if there was an expunged record, that it wasn't for a violent behavior, or maybe drug addiction. These people have access to medications, for instance.
Madam Chair, that's exactly right. That is what, if you hire someone to guard your chicken coop, you hope they're not a fox.
Right. Thank you. Representative Engen.
Thank you, Madam Chair. I actually object to Representative Liebling's assertion that because she doesn't know that much about expungement, that therefore we should just not give this a shot to pass. Because here's some of the, actually on the AG's website, the list of stays of adjudication that would be eligible for expungement. Giving a pistol to an ineligible person, a pistol without a permit, a transfer of a pistol to a minor, counterfeit, cell phone hacking, interfering with a bus driver, computer fraud, mortgage fraud, false certification of a notary, wildfire arson, general arson. These are all really, those are pretty serious crimes. And just because you receive a stay of adjudication does not mean that you should be entrusted with securing or ensuring the safety of people at a hospital or a domestic violence center, like Chair Scott had mentioned. So just wanted to put that on the record. Thank you.
I think, members, we're going to go to a vote, and all those in favor, excuse me, Representative Hudson, final words, and then we'll go to a vote.
Sure, I'll try to keep it brief. We've discussed this for a long time, but while I appreciate the point that Representative Engen is making, I'll just point out that stays of adjudication, as I understand it, are not something that would flag somebody from not being able to get a license. So we're talking about convictions here. It's a high standard. I think it's reasonable, and I would appreciate member support.
Representative Liebling has asked for a roll call, so the CLA will take the roll call.
Chair Scott,
Aye.
Chair Liebling, Vice Chair Hudson,
Aye.
Vice Chair Frazier,
No.
Representative Bliss,
Aye.
Representative Curran,
No.
Representative Duran,
Aye.
Representative Engen. Yes. Representative Feist,
No.
Representative Finke. No. Representative Mohamud,
No.
Representative Moeller. Representative Rarick. Representative Steer. Representative Moeller.
I know. Yep. There being 7 ayes and 6 nays, but it takes 8 votes to get a bill out of committee, the motion is not adopted. What? I thought you were asking for this. I guess Representative Hudson, when a bill fails in that fashion, it's laid over. So I move. So I move that House File 2825 be laid over. The next bill is Representative Agbaje. I think I saw her earlier. There she is. House File 1862 is before us. The motion is that it be laid over. Chair Liebling, would you like to move House File 1862?
Yes, that would be my motion, Madam
All
Chair.
right. House File 1862 is before us. Let's check for amendments here. I don't think there are any. I don't see any amendments, so Representative Agbaje, if you would like to go ahead and present your bill, that would be wonderful.
Thank you, Chair and members of the committee. I'm here to present House File 1862, which is a technical bill to clarify language so that the Office of Appellate Counsel and Training can complete its setup and begin its mission. So as background, in the last session, House File 922 was passed and became a law to establish the Office of Appellate Counsel and Training with the goal of providing attorneys for parents who are seeking an appeal on cases related to their children and child protective services. The attorneys from that office could be used in state cases, ICWA cases, and in tribal court. The office also has the responsibility of training attorneys for these types of cases and who practice at both the district and the appellate court level. This office will help support counties who may not be able to provide appellate attorneys as required by the state law that requires an attorney for indigent parents, parents who are in poverty, in child protection cases. Advocates had sought this office for many years, and the timing of the office also matched the start of the requirement that parents had a right to counsel in cases concerning their children. Yet after all the advocacy and the passage of House File 922 last biennium, the office has been unable to begin its work because of some administrative issues that require a legislative fix. And so one of these issues, which is what this bill brings forward, 1862, is that it addresses the lack of clarity around which branch of government would administer the office. The law was clear on how to appoint the board, which they have done, but it was not clear on the administrative functions like hiring an executive director and other staff. And that's why the office has not yet launched. So the language before you today was developed by advocates, the Office of Management and Budget, and a board member to ensure that the office could start effectively. The bill clarifies that the office will be part of the executive branch, designates the governor to appoint the initial chair from the members of the board, allows for the hiring of staff, and sets the compensation level for attorneys and staff. This bill does not require new costs since the funding for the office was already allocated and is ready to be used once this administrative clarity is implemented. I believe I do have one testifier joining remotely, so if she's online, we can turn it to her and then stand for questions. Thank you.
Ms. Woolman, I think, is with us, and please limit your testimony to 2 minutes if you can. We've been at this all day, so.
Nice to see you, Chair Scott. Thank you so much for your willingness to hear this bill. I don't have much to add other than what Representative Agbaje said. I will mention a couple additional things. A lot of work has gone into creating this office. Our justice partners, the Judiciary, the Guardian ad litem's office, the county attorneys and others support the establishment of this office. Parent representation in Minnesota is inequitable across the state. People who have a child removed in a more rural county have a really different set of resources and access to attorneys than those who live in the metro area. And so one of the things this office hopes to do is to be able to help provide a more equitable distribution of attorneys on appeals in Minnesota. And it's a very short turnaround. An appeal in a child protection matter from a permanent order is 20 days. I also would point out that with the recent passing of MIFPA and the African American Family Preservation Act, these two laws require comprehensive understanding of new practice and statutory provisions, and this office will be a true partner and help in ensuring that attorneys in Minnesota are able to fully actualize the promises of those two critical laws. As part of this office will also be charged with training. This office has been in the works for a very long time. We work to get a fix. And I'm so grateful to be able to testify today. I'm happy to answer any more specific questions. Thank you for your time.
Thank you, Ms. Woolman. Anyone in the audience wishing to testify on this bill? Seeing no one, member questions? All right, well,
Okay.
home run, Representative Agbaje. With that, any final words?
I just want to say thank the committee again for your time. Appreciate your consideration for this bill and the future policy package. So thank you.
Thank you. Chair Liebling renews her motion that House File 1862 be laid over. And it is. Representative Curran, House File 1373 is before us. Representative Curran, would you like to move your bill?
Yes, thank you so much, Chair. I move that House File 1373 be laid over for possible inclusion.
All right, the bill is before us. Go ahead with your presenting your bill, Representative Curran.
Thank you again. Thanks so much, Chairs Scott and Liebling. Civil legal services, or legal aid, as it's often known, provides critical legal representation to low-income Minnesotans in civil matters. Recent cost-benefit analysis shows that civil legal services delivers $4 back to Minnesotans for every dollar that's invested. That means more Minnesotans with secure housing, recouped payments, equitable outcomes in family court, and more. This is on top of the benefits our court system feels when parties are represented in court. But right now, 1 out of every 2 of our constituents who are eligible for these services and walks into their local legal aid office is turned away due to a lack of capacity. This denies Minnesotans access to justice, deprives them of financial security, and bogs down our courts. This bill continues the investments we made last biennium and allows more of our neighbors to access the justice they deserve. From there, I'll turn it over to our testifier.
Welcome to the committee. Please state your name for the record and go ahead with your testimony, and please try to keep it to 2 minutes.
Yes, excuse me. Thank you, Chair Scott, members of the committee. My name is Bridget Jernander. I am currently the staff attorney for the Legal Services Advisory Committee that will be transitioning to the State Board of Civil Legal Aid effective July 1st. We also have on Zoom testifier Dory Rappaport, who is providing the provider perspective, whereas I have a few statements about the administrative side of things. If we also have slides in your materials. Would you like me to start or Ms. Rappaport?
Well, let's go with our testifier that's online. And Ms. Rappaport, if you'd like to introduce yourself for the tape and go ahead with your testimony, that would be great.
Madam Chair, members of the committee, thank you so much for having us this evening. Again, I'm Dory Rappaport. I'm the Executive Director of Justice North. Civil Legal Services is a statewide system of programs delivering critical legal assistance to low-income Minnesotans. Today, I was told about a case where a legal aid staff attorney had to file an immediate action to protect children who were exposed to both violence and illegal drug use in the care of one of their parents. This action quickly removed the children to the safe care of their other parent. Normally, an action like this can take significant time, especially if the parent is unrepresented. But because this parent had a legal aid attorney, They were able to get their young children to safety in a much shorter time frame. Civil legal services is just one leg of the three-legged stool of the Minnesota justice system. As you can see in your handout, the other legs of the stool are the courts and the public defender. When all three legs are balanced, we can ensure that the justice system works for all Minnesotans regardless of their income. Victims of crime, veterans, senior citizens, and many other vulnerable populations would have no choice but to represent themselves in this justice system, if not for civil legal services. I'll now turn it back over to Bridget Jernander to talk about state funds management.
Thank you, Ms. Rappaport. Ms. Gernander, if you want to go ahead with your testimony now, that would be great.
Excuse me. Thank you, Chair Scott, members of the committee. So this is a transition year where we are moving from the Legal Services Advisory Committee that has been in place since 1982 to an independent judicial branch small agency called the State Board of Civil Legal Aid. So my job has been preparing for that transition. Primarily, our focus will continue to be on administration of grant funds and ensuring that they are efficiently and effectively administered, and as well as the work that, as all grant managers do in the state of Minnesota, to ensure that they're spent in line with the statute. So that is happening as of July 1st. On the next slide in your packet, another thing that my office does is collect statewide data about the services that are provided. So that includes financial data as well as case data. We have some information about the financial data that's collected through our office. This is a representation of all of the grantees when their total budgets are added together to show the portion that comes from the state appropriation, and then the other work that's done by all of the nonprofit organizations to try to maximize these funds. But that is the role that our office plays and that we will continue to play with the State Board of Civil Legal Aid.
Thank you very much. Is there anyone else in the audience wishing to testify? Seeing no one, member questions. Representative Liebling.
Thank you very much, and thank you for being here this evening. I just really can you just give us a little bit more about the transition that you've gone through and kind of what is because I wasn't here in this committee and involved in that, and I just want to understand kind of what's the improvement, if you think there's an improvement that we get from the current way that it's going to be set up.
To the testifier, Ms. Gernander.
Thank you, Chair Scott, Representative Liebling. I think that the main change that's happening is that having been part of the court system, I've been in this role for 17 years now, the courts have worked diligently to manage these funds, but it is obviously one of a multitude of things that the court system is taking on. In light of all of the Office of Legislative Auditor reports and other reports about the importance of focused grant management, I think the most important part of this transition is that there will be 100% focus on these funds and their impact on civil legal aid. Also looking at effectiveness, but the statute provides an additional a new component that is looking at the quality of the services provided, which we have not taken on before, as well as the effectiveness of the dollars themselves. So it really is a more comprehensive support of civil legal aid statewide.
Okay, thank you.
Seeing none, Representative Curran, any closing statements?
I'll just say thank you again, chairs and members, for your consideration. I appreciate it.
Seeing no more discussion, the bill is laid over.
The next bill is House File 1039. I will move the bill before us. Members, we will be laying this bill over for possible inclusion in our omnibus bill. Chair Scott, I see that you also have a A1 amendment. Would you like us to adopt the amendment?
Yes, Mr. Chair, I do have the A1.
Would you like to describe it all before we ask for discussion, or is it relatively simple?
I can explain to you what the amendment does. This amendment is based on feedback from the board, and with the initial drafted date on January 15th, we were made aware that the data would be approximately a year old at that time. So changing the reporting date to July 15th would allow the report to include the most recent grant information, along with the case closed data for the prior calendar year, since the grant contracts follow the state fiscal year. It also changes the reporting from once every 2 years to every year.
Is there
And ask
any-
for member support?
Is there any member discussion on the A1 amendment? Representative Curran? Oh, okay. Very well. Seeing no further discussion on the A1 amendment, all those in favor of adopting it signify by saying aye.
Aye.
Opposed? The motion prevails and the amendment is adopted. Chair Scott, now that the bill's in the shape you'd prefer, go ahead and speak to your bill as amended.
Thank you, Mr. Chair. This bill, well, let me back up a little bit here. Since the establishment of the Legal Services Advisory Committee in 2012, the court has required a written annual report on the work of the committee, including revenue received and grants made to civil legal services programs. Effective July 1st, 2025, the grant making that has been done through the Legal Services Advisory Committee will transition to the State Board of Civil Legal Aid. The State Board of Civil Legal Aid will be a new judicial branch agency, independent from the administrative control of the court system, similar to the State Board of Public Defense and the Guardian ad litem boards. This bill emphasizes the importance of a smooth transition to the new State Board of Civil Legal and promotes ongoing transparency, accountability, and effective resource allocation for Minnesota's civil legal aid programs. So what we're doing is just the report that was done before, we're just asking them to do the same report under the new makeup of the Board of Civil Legal Aid.
Thank you, Chair Scott. Is there anyone present who would like to testify on this bill? Seeing none, we'll turn to member discussion. I believe Representative Curran had a comment.
Yes, thank you, Chair, and thank you, Chair Scott. And as the author of the bill last biennium, who created the board, I appreciate you bringing this, and just wanted to put on the record that I have zero concerns and I signed on to this. So thank you for that.
Thank you.
Any other member discussion? Seeing none, I'll turn to Chair Scott for closing comments.
It's continuing the board's practice of transparency and accountability, and I hope that members will support it.
Seeing no further discussion, the bill is laid over, and we'll move on.
Chair Liebling, you have House File 3070 before us, and I do understand that your testifier is with us via Zoom. So the motion would be, did she say, oh, good? I will move House File 3070 before us, and members, this bill also will be laid over. Chair Liebling, tell us about your bill.
Well, thank you, Madam Chair, and this is the bill for the Competency Attainment Board. It is their bill, and I am not really I'm not really the person who should be presenting it or discussing it. We just, I threw the short straw to drop the bill so that we could get it before us and have the board in to talk to us as we're figuring out what to do with the budget and so on, and I think there's some policy changes as well. So
Perfect.
I would just ask the testifier to let us know about the bill.
All right, very good. Ms. Larson, Kim Larson, are you with us? There she is.
Yes, Madam Chair. Hello.
Hello, Kim. Thanks for joining us this late in the day. Please introduce yourself for the tape and go ahead with your testimony about the bill.
Great. Thank you, Madam Chair, members of the committee. I'm Kim Larson. I'm the State Program Administrator for the Minnesota Competency Attainment Board. And thank you to Representative Liebling for drawing the short straw for us. A little bit about the board. We were created in 2022 as an independent board within the judicial branch. So just as you heard, similar to the Board of Public Defense, Guardian Ad Litem Board, and now soon to be the Board of Civil Legal Aid. The statute establishes a forensic navigator program, and forensic navigators are appointed by the court in criminal cases where there are questions about the defendant's competency to stand trial. Forensic navigators are impartial participants in these cases, and they're charged with helping defendants attain stability and competency so that they can resolve their case. They do this by connecting defendants with services such as housing, mental health and substance use treatment, and other supports based on each individual defendant's needs. Defendants that forensic navigators work with receive services from a variety of programs, some of our defendants are eligible for competency attainment services through, for example, DCT's AMRTC program, which is a locked hospital level care facility. But the majority of the defendants that our forensic navigators work with are residing in the community or are still in custody. You have two handouts, I believe, in your packet from us, one that discusses the bill and one that's an agency overview. Our bill has two parts to it. The first part are policy changes that were approved by the board for submission, and then the second part is an appropriation that matches what we originally submitted several months ago. The policy sections of the bill cover a couple of things that I'll go over quickly. So the first and most space-taking up change that we're looking for is shifting the term currently in the statute that is supervision and changing that to monitor. And the purpose of that is to clarify that forensic navigators don't have the same supervision role or authority as other agencies such as probation and pretrial services. The second policy change is just eliminating a data collection duplication, which would change the statute to allow us to obtain reporting data that's already collected by the State Court Administrator's Office and use that data in our mandatory annual report to the legislature and partners. We would still, our program would still collect and report to the legislature on forensic navigator specific data, so such as how many were assigned to cases. And then the third policy change is just eliminating the requirement for board membership to include a former forensic navigator. And then, like I mentioned, the appropriation portion of the bill really just reflects an increase in funding to support our continued growth so that we can fully meet the needs statewide and support the board's core operations. As indicated earlier, the amounts that you see in there were aligned with our original budget request that was submitted prior to the February forecast and budget targets. The board and the Forensic Navigator program, I'm really happy to report, crossed the 1-year anniversary just earlier this week. April 1st, 2025 was 1 year past our initial effective date. And in the last year, we've made a lot of positive progress, but we still have room to grow, and there still are needs that we need to be able to expand to meet statewide. Your support of our bill would mean that we can continue to mature the organization to become what was envisioned by the 2022 legislation and consistently meet the needs of the courts and defendants statewide. And I'm happy to answer any questions the committee may have.
Thank you, Ms. Larson. Thanks for joining us in that good overview. I do have a question for you. When we met with you a few weeks ago, I think you were saying that you thought that you were going to be making offers or onboarding 7 forensic navigators, and I'm just wondering how that turned out.
Yes, I'm happy to say that we currently have 24 forensic navigators employed, and as of next Wednesday, we will have 30. So we will be adding 6 additional forensic navigators to our complement, and that will put us at 30 total.
Thank you for answering that question. Is there anyone else in the audience wishing to testify on this bill? Seeing none, we can move to member questions. Seeing none, Chair Liebling, do you have any final comments?
No, just appreciate the board and that it's good to hear that progress is being made in onboarding folks and, and that's it. Thank you for hearing it.
Sounds good. All right, members, without House File 3070 is laid over. We have no further business before the committee. You are free to leave. We're adjourned.